We will go ahead and call the subcommittee for Senate Joint Resolution 2002 to order, a joint resolution proposing an amendment to the Constitution of the state of Iowa prohibiting the power of judicial review. This has been filed by Senator Taylor. I will open, after we have comments, I will open with a pro there, the bill sponsor. We'll certainly take input around the room then following that, and just move on like that. At that time then, Senator Blake, Senator Rosenboom, do you have any comments?
I have lots of comments, but I will hold them.
Okay.
Well, and I'll just say this, obviously this landed on my desk, and I assigned the subcommittee because it is a proposed amendment to the Iowa Constitution, which goes through the state government committee with open for the judiciary, I'm sure. And I understand the weight this kind of thing carries, and we'll let Senator Taylor speak to that. But so we talk in this room or subcommittee meetings about having a conversation. So I guess let the conversation begin. I'm listening.
And I was happy to, so our history is Senator Taylor and I have had the greatest historical constitution from originalism, the philosophy, and I'm like, yes, I will go ahead. And I said, well, you may as well put me on there. I'm familiar with the topic. So with that, Senator Taylor.
Thank you. Well, first off, I will say that this is not something I take lightly. This is a serious proposal, but at the same time, I realize that this is surprising. I realize that this would significantly change the system that we've been operating on for many decades in our state. I don't know how far the resolution is going to get, but I do appreciate the state government allowing a public hearing to think about, talk about this particular question. I also want to say that no disrespect is intended to current judges or past judges in the state of Iowa. They have operated within a long-standing tradition. They've operated in good faith. And also I want to stress that this idea of changing the Constitution has nothing to do with specific laws that the courts have either decided to affirm or strike down. It's not, I'm not trying to play favorites, and there's nothing personal in terms of the personnel or the laws that have been involved. But here briefly is my rationale for proposing this constitutional amendment. Even before becoming a lawmaker, I believed in the importance of the legislative and executive branches following the Constitution, and I continue to care deeply about that. There are various ways of holding these two branches accountable. At the state level, I am proposing that the people are ultimately the appropriate watchdog and enforcer of constitutionality. In addition, the governor is tasked by the state constitution with choosing whether or not to sign bills that are passed by the House and the Senate, which provides another check and balance. Like the U.S. Constitution, the Iowa Constitution does not even specifically grant the power of judicial review to the Supreme Court. At the federal level, the court gave itself the power in Marbury v. Madison back in 1803. This was inappropriate, as President Jefferson noted at the time, but it became a self-interested and self-perpetuating tradition. State high courts, including Iowa, have followed that tradition. Judicial review was a significant departure from the English tradition. Courts in England could not set aside laws enacted by Parliament. Alexander Hamilton, one of our great founding fathers, disliked this feature of English governance, but he conceded in the Federalist Papers that the Constitution did not grant the Supreme Court the power of judicial review. In our state, it is a tradition that undercuts popular sovereignty, in other words, the democratic aspect of our republic, and it does not allow the legislature to override the court's veto, unlike what is granted in the Constitution in relation to the governor's veto. This has resulted in an imbalance between the branches, in my opinion, an imbalance not authorized by the Constitution. The legislative branch should determine public policy for Iowa. Judges who are not chosen by the people should not have a de facto veto on laws created by the people's elected representatives. Courts should confine themselves to the interpretation and application of laws. And finally, I would just say that Iowa voters, after the governor has had her say, yes or no, on bills that arrive at her desk, ultimately Iowa voters should hold legislators accountable if we enact unconstitutional laws. Thank you.
Thank you very much. Well, I'm going to guess, are we comfortable starting over on this end?
Sure.
We'll just go ahead. It seems like a more easily divisible line right here.
I'll
this
save
time.
the camera for somebody. Come on now. We have a deal.
Kelly Kashke on behalf of Justice Not Politics and the Iowa Association for Justice, here obviously registered against this legislation. This resolution, as Senator Taylor noted, will eliminate the process of judicial review, which is the court's authority to determine if laws are consistent with the Iowa Constitution. The bill contains a very narrow exception that would allow the courts to continue reviewing redistricting legislation. As conservatives, you profess to believe in limited government. The founders designed our system with just that in mind: 3 co-equal branches of government for the purpose of preventing any single branch from accumulating unchecked, unlimited power. Eliminating judicial review doesn't strengthen the legislature. It removes a critical safeguard against government overreach and eliminates the rights of Iowans. Consider this: Republicans will not always control the legislature and the governor's office. In fact, many of us were here when there was a Democrat trifecta. At some point, Democrats will control the legislature and the governor's office again. And do you want them passing laws on unchecked power? Who will enforce the rights of the Constitution, the rights of Iowans, if it's unchecked by the courts? The Iowa Constitution means nothing if it can't be enforced. Judicial review is that enforcement mechanism. It doesn't give courts unlimited power or unchecked power. It provides them with the responsibility to uphold the Constitution we all swore to defend. The power you're attempting to wield today will render the future you powerless. We urge you to vote. Thank you.
We have a few more back there?
No,
Are we good?
Designated focus.
I understand, just wanted to make sure.
Thank you, Senator.
Yeah, so I'm Curtis Bauer. I am currently registered in opposition of the bill as it stands right now. Echoing some of the things that Senator Taylor has outlined, I believe the exact reference was in Federalist 81, where Alexander Hamilton had stated that it does not explicitly say that the courts have the power for judicial review. And that is true in Article 3. They do not. But what it does say is it says it has judicial power. And Marbury v. Madison came out in 1803. And if you were to look at from Federalist Paper 78A through 82 or 83, where Alexander Hamilton lays out judicial review in different ways and what the power of the judiciary is, I differ in opinion with Ms. Paschke on Alexander Hamilton, who is one of the founding fathers, did say that the judicial branch is the weakest branch. And they do not hold the power of enforcement, they do not. However, in 78, what was stated by Alexander Hamilton at that time was that, and this was in 1788 when he wrote this, was that if a piece of legislation came forward that was a statute or a proposed statute, and it was inconsistent with the Constitution at that time, the Supreme Court had the power to be able to render it void. And when you look at that ability to remove that component, that's a big, big deal. So I agree that with the spirit and intent of what Senator Taylor is doing, because I think there are times where our judiciary has overstepped its bounds. And unlike Senator Taylor, I'm willing to go into examples of that and name names. I'll give you just a few. Plessy v. Ferguson, Brown v. Board of Education. We had to undo a grave injustice. Separate but equal is inherently unequal, is what Earl Warren penned. That was in 1954. And you know, to the point of, if we're gonna go to partisan politics, one of the things that's very near and dear to conservatives is Roe v. Wade and Dobbs. You guys didn't believe that Roe v. Wade should have existed. And then when Dobbs undid that, well, there's another example of the judiciary rectifying a perceived wrong. So wherever you stand on the issue, you're gonna want the judiciary to have the ability to render a statute that is inconsistent with the Constitution void. If not, it's a slippery, slippery slope down a very, very steep ravine. That's all I have, thank you.
I'm Connie Ryan, I'm the Executive Director of Interfaith Alliance of Iowa. I also happen to chair Justice Not Politics, but I won't speak to that. Kelly did a fabulous job, whether or not she was on camera or not. But we are strongly opposed to this legislation. Just a correction, I won't speak specifically to the bill, but a correction to the senator. Our judges and justices are, yes, appointed by somebody who is elected by the people through a nominating process, but then they also are retained by the people. And so that is something that is key to our retention process, nominating and retention process. And so they are retained or not based on their skills and their ability and all the things that come with being a judge and justice. So I just want to make that piece of it.
Okay.
Keenan Crow, One Iowa, we were registered against the bill. I don't have a ton to add except to just note that judicial review is a crucial mechanism for protecting individual rights against the tyranny of the majority. If we go back to Plessy v. Ferguson, what that case essentially did was reiterate that the majority could create a system of separate but equal. What Brown said was no, the courts are going to in fact protect individual rights in this case. And so if we believe that was the correct solution, we are in fact eliminating the mechanism that made that come.
Peter here with the Iowa Federation of Labor. We're opposed. I don't have anything extra to add.
Nathan Arnold, Professional Educators of Iowa. We're registered against the legislation. Alexander Hamilton in Federalist Paper 78 did express a desire to have the judiciary as a check, because if the same entity that passes the laws also decides if those laws are constitutional, then you know the Constitution essentially becomes parchment. Now, there's no one who gets more frustrated than me about judicial overreach, and I think every branch of government has the ability to potentially take too much power, and the judicial branch is not exempt from that. However, I don't think that the solution to that is to give all the power to the other branches of government. Even though we do want an independent judiciary, there are democratic checks. For example, the democratically elected governor picks the judiciary. In Iowa, there's actually retention elections for our Supreme Court. Additionally, this wouldn't change the federal court system. Federal courts would still be able to rule things unconstitutional. This wouldn't impact that. So for all those reasons, we're against the bill.
Oh,
Yes.
yeah. Hi, Amy Campbell. I represent the League of Women Voters of Iowa, and we're opposed to the bill. Sorry I didn't get my registration in until right before this started off. I won't repeat what others have said, but to Senator Taylor's point on the check by the citizens, despite your work on trying to improve constitutional literacy, only 5% of Americans can appropriately name the 5 rights of the First Amendment, and only 30% get 3 or 4 of them right. So I don't think that a citizen check in this way on constitutionality is equivalent to what we have in place now. Thank you.
Mike Keller with the Academy of Trial Lawyers. We're opposed to the bill. Jim Curran. I'm good. I'm just monitoring.
We're just monitoring.
All right,
Thank you.
Jim Kearney on behalf of the
I
Iowa
thought so.
State Bar Association, and surprise you to know that we're opposed to the bill. Right? Thank my good friend, Professor Taylor, and I invite him to go to law school.
You may be too late for me.
But no history lesson on the Constitution or anything from us. We believe it's a separation of powers. There's also issue, but there's also an issue of whether or not, if the Iowa Supreme Court has not ruled on a case, can that case then go to the Supreme Court? And it cannot if there's a state claim. That's a very, very important aspect of this that's not been talked to, and I'll be happy to share more information with you about that. That's really important. If there's no Supreme Court decision by an Iowa court, okay, you can't go up to the U.S. Supreme Court. That's a biggie. Thank you. Thank you, Jeff.
I think that's all the way around. We have several people online. If you would like to raise your hand, we'd be happy to call on you. I'm not seeing any hands right now.
Pam Taylor.
Oh, there we are, Pam Taylor. I'm sorry, I was actually looking at the wrong side. Pam Taylor, you are ready.
My
Please.
name is Pam Mackey Taylor. I am representing the Iowa chapter of the Sierra Club. And I'd like to reiterate that we have 3 branches of government for a reason. They provide checks and balances. And if a court doesn't have the capability or capacity or the legal authority to rule a bill unconstitutional, who really does? And I would also like to say if we stop passing unconstitutional laws, then we won't have to worry about laws being overturned by the courts. And that seems to be a thorn in the side with some legislators. Let's talk about who's responsible to the people. The legislators are elected by the people and they can be voted on. Judges also are voted on for retention. And further, in Iowa, we have a commission of citizens that names the judges who are nominated, names the folks who are going to be nominated to be judges, and then the final selection being done by the governor. So it's citizens that help nominate those judges. Iowa judges also have a mandatory retirement age. That's unlike what's happening with the U.S. Supreme Court.
Is that, are you finished? I don't want to interrupt. Ma'am? We may have lost her, because I don't want to interrupt her.
It's frozen.
Oh, the system froze. All right. We will see if it starts again, but otherwise we may. Pam, are you back? If you can hear me, Pam, you can unmute.
Try again. Say that again.
Pam, you can go ahead and unmute if you had more to contribute. She may not. That may have been about it. I'm seeing no other hands online. If anybody else would like to, going once, twice, 3 times. Okay, then we will go to the senators. That'll work. We've been all the way around. Would you like to go first or second or third?
I can go. This, I think, has been clearly demonstrated here today that moving this forward is frankly a very dangerous concept. The ability of the judiciary to be a co-equal branch is predicated on this idea that they have to be able to review our decisions. Without the ability to review the laws, the Constitution is meaningless. We can do whatever we want. And the concept and the idea that elected officials are held by the voters is absolutely true. I'm not trying to refute that, but their legislatures or subsequent legislatures could do damage to the people of Iowa that may not be reversed in time by an election. I'm thinking things not even just minority rights, and I'm not talking about minority, I'm talking about those that don't have power. They would be potentially trampled over, or even like something like the taking squads, where we would have the authority to take people's property without check, because there's no judiciary to stop that from happening. Yes, there's people, but we may have already taken property by that time. The implications of not having a check on our authority is grave. And to me, it basically would upend the ability of us to be a constitutional democracy in the first place. So I am strongly against this resolution. I could keep going on, but we've heard some very fine points made by other folks. That's why I will not be voting to support this moving forward.
Okay. Would you like me to, or would you like to?
Well, no, I'm gonna leave the burden on you at the end. I clearly am probably the least qualified to speak to this, other than having a title. I'm not a lawyer, nor have I ever served on the Judiciary Committee, and I fully recognize that. I'm gonna give my, this time to Senator Taylor to see if there's any rebuttal. Is that fair?
I think that's
that I give you the floor. Certainly, I'm not going to speak to the merits or demerits of the bill because I'm not qualified to do so. But, and by the way, just to be clear, the State Government Committee is a process. And so I'm here from a process perspective, I would say, more than anything else. So Senator Taylor, I would yield my time to you.
Well, thank you. I guess I would say in response to the reference to the Federalist Papers and Alexander Hamilton, as much weight as Hamilton carries, and as much as important as those, what began as newspaper editorials, but later packaged as in book form, as important as the Federalist Papers are, it does not carry equal weight with the Constitution. And unlike Hamilton, I am a Jeffersonian in believing in strict construction, or in other words, literal interpretation of the Constitution. I think, you know, the real danger, whether it's judges or whether it's politicians, comes when we don't stick to the actual words of the rule book, but instead we kind of squint and somehow see these powers and authorities that are not spelled out. And so I just disagree with Hamilton's point of view. He was a big government kind of guy. He was a centralized authority. He was skeptical of any aspect of democracy. He referred to the people as a rampaging beast. So I just am not in sympathy with his point of view, which as much as possible wanted to remove power away from the people and put it into the hands of the few rather than the hands of the many. And so for that reason, I think when we say that constitutional democracy would be at stake, I disagree, partly because I think this is a more democratically inclined proposal, and secondly, in terms of being a constitutional democracy, I think if judicial review is an important check on the legislature, it seems odd to me that it actually isn't contained in the Iowa Constitution. When I asked LSA to draft this bill to remove the power of judicial review from the judicial branch, I expected, well, they would probably delete something. No, they left the Constitution as it is and just added a sentence saying judicial review is not permitted. So again, there's an irony there that the very power of the courts to decide whether or not something is constitutional, that very power is not in the Constitution.
Can I ask a follow-up question, Senator? I'm very much a layman here, but tell me how challenges then to the laws that we pass, how you envision that being carried out.
Again, I guess it would be a twofold check and balance in my view. These balances already exist. We would be taking one of them away, that's true, but we would continue to have the governor acting as a check and a balance in deciding whether to sign or veto bills that arrive at the governor's desk, and then ultimately the people would make the decision whether or not something is constitutional. And as we know, I mean, Jim isn't here anymore, but we have lawyers arguing all the time. There's always at least two sides to every legal dispute, right? So it's not crystal clear as to what is or is not constitutional, but then the question is who ultimately should decide that? I would argue ultimately it's the people.
Can I jump in really quick? So here, I'm just to follow up on that thread that it's the people's decision. What if we as the legislature take the right of people to vote away? And there's no enforcement. What if we take the people that disagree with us and tell them they can't vote anymore? And there's no check on that. Sorry, I was gonna,
go for the gold.
No. How are they supposed to voice their opinion when we could, in theory, if the majority decides that the minority doesn't have the right to voice their opinion democratically, how are they supposed to be able to voice their opinion in our constitutional democracy?
Well, that is a worst case scenario of a hypothetical. First of all, I don't think it will ever happen. In that case, well, I'm not even going to answer that question in terms of that hypothetical, because we know that's not going to happen.
Do we?
Yeah, we do. And as pointed out earlier, the courts do not have enforcement power. Even now, they rely on the executive branch to enforce the opinions that they render. And so ultimately, it is the people who have to be able to enforce the idea of living in a free society, the government following the rules, and all of that, all of those basic tenets of constitutionalism.
Everything? We got that? Are we satisfied?
Yes.
I'm enjoying this immensely, to be quite honest. Okay, so I guess the final word here. Now, my understanding, and I guess I want to make sure you understand it right. So, I think the current procedure is that every constitutional amendment goes to the state government.
That's correct.
And then to the policy committee of relevance.
That's my understanding.
I-
We can clarify all of that.
We can. So essentially, we have both chairs right here that would.
We do.
That would.
We do, which, yeah, I put myself on this for that reason.
I'm not.
We'll have this discussion.
If it would come out of state government, I'm not going to run it out of judiciary.
Okay.
I don't believe this is correct, ready to go to the House or to the people. But this is I think, an incredibly important discussion. So, so we know the future of this. I don't know if you would bring it up in state government. That's your decision after subcommittee. I'll cut to the chase. Out of respect for our conversations over many years, going back 10 years, my belief that the founders wrote the Constitution on purpose and did not include this in it, the fact that the people who wrote the Constitution were still in office and could have amended the Constitution to put it in had they chosen to. I'm going to sign the subcommittee report. I don't expect either of you to do so. I mean, that I'm going to do it out of loyalty to what I have always believed, that Marbury versus Madison was erroneously decided and was simply a game of nerve between our earliest judges, our earliest executives, and a lack of action on the legislature, Congress. They didn't put it there. They could have put it there, and they decided not to. But this will not go to the Judiciary Committee, probably not the State Government Committee. It won't go to the House, and it won't go to a vote. But it is something that I think we ought to recognize historically. This was in Marbury versus Madison. I'm looking to the professor to make sure that I state this as he and I remember conversing. This was the strongest power grab to happen early in the country, and we are supposed to be a constitutional republic where branches do not grant themselves power. They are granted power by the Constitution as decided and ratified by the states. Nobody gave them permission to do this. They took it, and then through a game of nerve, they kept it. I want to recognize that with my signature. I expect neither of you to sign unless you want to, or you want to, but you've already said you won't. So I'll leave that to you, but I don't expect to see this in a committee myself.
So you managed to turn this into a guy that's at least qualified. Okay.
No. I wouldn't bring it up.
I hope he's going to get my 60.
Yeah. There's no pressure, because I won't bring it up in
Well,
judiciary.
I've only been here 14 years. I just haven't been in this situation before, for obvious reasons. And Senator Taylor, who I respect immensely in terms of his constitutional knowledge, which exceeds that of virtually everybody here, I don't know, but it's high. So I'm going to, I don't want to use the word punt because I don't think I'm doing that. I want clarification. I think I have some time to consider this before I make the decision whether, so I'm going to decline to sign it for now, but I want to have discussions about process and out of respect to my colleague, before I make a final decision that I may regret, and something I'm not thinking about right now. Does that make sense to everybody? I hope so, because that's the way it's going to be.
Okay, that'll work. With that, we will adjourn the subcommittee, and I thank the senator for bringing this to us. I thank everybody for coming in. The discussion was as historically interesting as I expected it to be. I've been looking forward to this. Thank you very much.
Senator Schultz, will you take any follow-up questions?
Sure.
Why, if you agree with it as a concept, why wouldn't you bring it up in your committee?
I don't know that the caucus is ready for that.
Oh, I see.
The Judiciary Committee, the full caucus, or the people of Iowa to have it put before them.
And what about the idea that by the time the Iowa Constitution was written in the 1850s, judicial review was very well established in the rest of the country, federally and in other states. So maybe it wasn't explicitly written into the Iowa Constitution because it was understood that that's how it works.
That's a possibility. I recognize that they may have had that conversation without it being documented and decided that. It could be. I don't have a strong position on that.
Okay. All right.
I think that's a valid thought.
And as somebody, I'm a member of a religious minority group myself, so I mean, this is a very real concern. There have been times in history where perhaps a legislature might have decided we're not going to allow any synagogues or any mosques, and what would be the recourse? I mean, the majority would probably not vote out of office legislators who, you know, trampled on religious freedom for a minority group of less than 1% of the population. So what would be the remedy for that?
As Senator Taylor wisely said, I'm not going to speak to hypotheticals when we've already said we're not going to move forward.
Okay, all right, well, thank you.
I appreciate the questions.
Okay.